And Michael Timberlake with our friends at Timberlake League, and Brooks joins us this morning. First of all, how are you doing?
Well, I'm doing great. How are you?
I'm well. I like to do a check-in, just to see how we're doing before we get in, because today we are talking about whether a case should settle or if it should go to court.
Right. I mean, it's one of those things that we deal with a lot in terms of, litigation. That's kind of a question that everybody wants to answer. Right. Is my case going to settle, or am I going to have to go to court? And it's one of those things that we try to worry about on the front end when we talk to clients. And typically, most cases resolve. Most cases do settle, and either with or without litigation. If a case goes into litigation, then it doesn't mean that it can't settle, but it just means that you may have to go through the discovery process, provide testimony, provide more information before you get to the resolution of the claim. Typically, in my world, injury cases will get into litigation based upon one of three things. Whose fault was it? Was it somebody? Is there some question about who caused the injury or who caused the accident in question? The second thing is, are these injuries related to the incident? So, if you've got a pre-existing condition, if you have problems in the past, if you had a similar type of injury in the past, then that claim may have to be litigated, may have to go to court so you can get doctor's testimony to establish what the exact injury is. And then sometimes we just can't agree on what the exact amount should be, what a jury may do if the case goes to court. So we go try the case and let a jury tell us what it's worth.
I like that you do that, because some folks feel like sometimes going to trial is a little bit too much of a headache. It's just too many pieces to put together.
Right. Well, I mean, you try to, this is what we do. The only people that like courtrooms are lawyers and judges, typically. So really, in this situation, what we like to do is tell our client that you got to be prepared to go, and that's the way it gets you the best option for resolution.
Well, we do have a caller on the line.
Okay, great.
John, are you there? John? Okay.
Oh, we lost John.
We lost him, but
that.
that's okay.
Well, I mean, so we're talking about, whether you need to go to court or not. And if a case is prepared correctly, like you're going to go to court, then you're going to end up with the best outcome. If you end up with a lawyer that doesn't want to go to court, or some firms kind of operate like glorified collection firms where they just take whatever's offered, then you're not going to get the best result.
So are there some red flags to look for so that some people don't fall into that trap?
Well, I mean, ask your lawyer. When's the last time you've tried a case? How many cases have you tried? Do you try cases before the jury? You'd be surprised at how many lawyers don't.
That is interesting, because I never would have thought to ask him that. But you know what? We're going to put that on pause, because John, are you there now?
Yes, I am.
Hey, go ahead with your question.
I was just interested in why the state of Alabama, as long as several other states, do not recognize an ex-spouse as a legitimate life insurance recipient as far as for a beneficiary. My ex had left me a small life insurance policy that she never changed from our marriage. However, it was then passed on to her children, which to me is fine. I was just curious why some states do and some states don't.
Yeah, I mean, it's a policy question that really depends upon what the legislatures or what whether the law has even been presented. In your situation, I think there's kind of a presumption that once you go through a divorce, then that person doesn't want you to be the beneficiary of that policy anymore, and it would go to basically the next heirs in line. But that's just a policy decision that they make in Montgomery, and for good or for bad. There are probably good reasons for it or bad reasons for it.
Is there any situation as to where he can actually try to fight to get that money?
I mean, obviously you'd want to look at the. I think if the law is in place and the beneficiary has changed, or not been changed, but there's a divorce, the only way to do is affect that is to change the legislation.
Okay, well, there you have it, John. Thank you so much for calling in. And if you happen to have a question that we did not get to, don't worry, we do this segment every single Monday. We also have it on Sunday nights as well. And you can also go to the blog, law-injury.com/blog. for any questions that you may need answers, if they're frequently asked questions. Well, I want to thank you so much for coming on.
Well, sure. If you got other questions, you can look on the blog, or you can call us at our office.
Love it. Well, thank you again.
Thanks.
And we'll see you right after the break.